All right, everyone. Welcome so much to today's webinar. This is Meta Earlywine with the Washington State Coalition Against Domestic Violence, and I am here with Emily Cordo from the YWCA and Kelly Ambergy Richardson from WSCADV, and we are very excited to be here today to talk to you about what to do when you get a subpoena. This is a question I know that Kelly and I hear from you about quite a bit, and so we hope that Emily is going to be able to provide you with really clear instructions or guidance, not advice, about what you can do as a non-attorney at the program level when you get that subpoena. So we're really glad you're here with us. I'm going to go over just a couple of slides about how to use our webinar system, and then I'm going to turn it over to Emily because she has a ton of wonderful content to share with you. So. And again, WSCADV and WCSAP are really happy to be co-hosting this. And just to let you know that we are going to be recording it, so if you have coworkers that need to get this information, that will be available to you probably in a week or two. We'll put that up on both of our websites. So check back for that. Okay, so since there are a lot of you on this webinar, we've got everyone on mute. And we hope that you're listening through your computer speakers, but if for some reason that's not working, you can always press the telephone button. If the speakers aren't working, you won't be able to hear me say this, so you can see it on the slide. If you can't hear me, please select the telephone button and follow the instructions from there to listen through your phone. Again, everyone's on mute, so we are asking that you please use the question box to communicate with us. I'll be watching the question box and giving Emily a heads up when there's questions. And she has said that she really wants people to feel free to ask questions as they go along. So please do that, and then I'll find times to interrupt her and get your questions answered. So same for Kelly. She'll be helping me watch out for that. And just a pro tip that if your control panel, which you need for asking questions, minimizes to the side of your screen, you can just click that orange arrow to get it back. And then finally, there's going to be an evaluation form that will pop up at the end of this webinar. The first question is going to ask you who else from your program was sitting around the desk with you. Please fill that out. And then also let us know if this webinar was useful for you. We really value your input, so thanks for that. Okay, so without further ado, I'm going to turn it over to Emily. Thank you very much. Thank you. Ready.
All right. Hi, everybody. So the point of the presentation today is mostly to make you feel more comfortable having a sense that you know what to do when you get a subpoena or any other form of legal request for information. You have some sense of how to respond, and you have the ability to determine whether or not this is something that you can handle or whether you really do need to try to find an attorney to help you out with this. The presentation is fairly dense, by which I hope I mean full of information and not slow-witted. But the key being, I'm going to do my best to explain things in a clear way, but I really hope that if at any point I'm using any jargon that you're not familiar with, lawyers have a tendency to do that, even when we try our best not to. Or if I'm just jumping ahead too quickly, please do let us know. I'm happy to answer questions throughout the presentation, and I will also try to reserve a little time at the end for that as well. But without any further ado, unless there are any sort of preliminary comments, I'm going to cover some sort of general topics in the beginning, and then I'm going to talk really specifically about three kinds of requests for information that are particularly common at programs like yours, as far as I've been told. Those include subpoenas that request that you provide client records, subpoenas that are asking you to appear at a deposition, and subpoenas that request that you would be present at trial to testify as a witness. So I will cover all three of those in I'll try to cover all three of those in more detail in the second half of the presentation. It's important for you to remember that this area of law is fairly complicated. There are a lot of different laws and rules that apply, and it's something that many attorneys don't do correctly because of these complications. So you shouldn't expect that you're going to be an expert or feel 100% comfortable with any of this material by the time we're done with the presentation. I'm not telling you what to do. I will at points give you suggestions about how your programs might approach it or what I consider a best practice. But again, this is not legal advice, and it's not necessarily specific to specific rules that you may have in your county. Some counties have some additional rules that address especially the procedure for doing some of these forms of discovery. So if you're concerned about that, it is best to check with a local attorney in your county. And then just as a side note, federal courts are known to be hesitant to enforce privileges that are created at the state level. And so the material that I'm presenting is really only applicable when we're talking about Superior Court in Washington State. So I'm pretty confident that anyone working for any of the advocacy programs that I know are participating on this webinar are really familiar with the importance of victim privacy, whether that's a domestic violence victim or particularly a sexual assault victim. And one of the important concepts that underlies any conversation about privilege or confidentiality is that the right to confidentiality or privilege belongs to the client, the victim. It doesn't belong to the advocate or the program. And there are a number of reasons that the client really has to be at the center of decision-making regarding all of these kinds of subpoenas. One of the reasons for that is that VAWA has specific provisions that allow penalizing programs financially if they don't follow VAWA rules regarding client privacy. Individuals at the programs as well as the programs as a whole can be potentially liable for improper disclosures that are made. I say this not to scare you because there are a lot of things built into the law to protect you. For example, the law presumes that if you release information that you're doing it in good faith unless it's proven otherwise. And good faith is a defense against these kinds of lawsuits. So I don't want to scare you, but it is important to be aware that these are decisions that have legal consequences. And then, of course, as you experience in your day-to-day advocacy, you're aware that protecting your client's privacy is really critical to both their safety and emotional well-being, but also their willingness to believe in the future that they can trust you and their doctors and their counselors and their attorneys and anybody else that they're interacting with who assures them that their information will be kept private. Actually keeping their information private is really essential to maintaining that trust. As you're also probably aware, there are essentially two types of laws that are the most significant in terms of the protection of your client's privacy. Those are privilege and confidentiality. Washington State is we're really fortunate to work here in that Washington has privileges that protect both advocates for domestic violence victims and advocates for sexual assault victims. The important thing to remember about privilege is that privilege relates to your ability to speak, and that would include a subpoena to testify at a trial, for example. What privilege does is it makes you as a person incompetent to testify. So just like a 2-year-old or somebody who's in a coma are not competent to testify at trial, they are categorically excluded from being able to testify because they are not capable of it. That is essentially the status that you as an advocate have through privilege. You are not considered somebody who is competent to be a witness. Confidentiality is different in the sense that confidentiality laws and rules are really about documents and things and about who has the right to control that information. In the context of subpoenas for information, and in general in regard to client records, that person is your client, the victim. They're the ones who have the right to that control. So the terms privilege and confidentiality are often used fairly interchangeably, but just keep in mind that, again, privilege relates to testimony and confidentiality relates to access to information or records. And probably most of you are familiar with the VAWA privacy rules, so I'm not going to cover this in too much depth. But generally speaking, if you're going to release client information, you need to have either the victim's consent or a lawful statutory or court mandate. Now, one of the things that can be confusing is that a subpoena oftentimes starts with language along the lines of the state of Washington commands you to do X, Y, and Z. And so it sounds a whole lot like a mandate. But there are a lot of reasons that a subpoena may not be lawful, and so that is not considered enough under VAWA. That's one of the reasons Washington's laws that create a process where the court has to intervene are really important, and we'll talk specifically about this in a minute. The other thing to keep in mind with regard to VAWA is that in implementing VAWA, a lot of programs create policies that specify how they're going to deal with particular situations. And one example that I'm aware of is the WSCADV policy on how to deal with the information of clients who are minors. Now, while technically the Washington laws that relate to privilege and confidentiality are not, don't necessarily take into account potential variations in policy from agency to agency, there's also a lot of wiggle room when it comes to discovery. There are a lot of gray areas, and there are a lot of legal questions where the standard is very vague. It's something like a good cause or adequate cause or reasonableness. In the context of having that kind of wiggle room, you may be able to actually use your own agency policies as additional arguments for why it's important that you need to have a consistent policy of not releasing information in certain contexts. So don't forget about your own individual agency policies when you're considering how best to resist a request for information.
Hi everyone, this is Kelly at WSCADV, and I'll just say that was our guidance to programs that they can create policies because there are lots of places in Washington law that allow minors to consent to other types of services that are similar to advocacy services.
So we're going to talk specifically about subpoenas, but there are, I would want to note, a number of ways that you're able to protect client privacy before you even get a subpoena. One of the most important is simply informing your clients about their privacy rights and the limitations on those rights. My opinion is that it should be standard practice to have a conversation with every single new client about this issue. And that is because it is so critical to victims' well-being, and it's not the kind of information that they really have easy access to anywhere else. When you begin interacting with a client is really probably the first time that many of them will ever have encountered somebody who has the capacity to explain those sorts of rights to them. So I really hope that that's something that all of you are doing, and I suspect that it is for most of you. Another thing that you can do and probably do regularly are help client when there are requests for them to waive their privacy, whether that request comes from law enforcement, whether it comes from your own program or anybody else. When those kinds of waivers are requested, helping the client know how to tailor those as narrowly as possible to make sure that nothing unnecessary is released, and making sure that they're really informed about what they're signing is absolutely critical. You, I'm sure, consult with your clients before releasing their information to anybody, whether that's informally or formally through the discovery process. Thinking carefully about who needs to know what. I oftentimes work very closely with advocates when we have a client in common, and it's something that I struggle with constantly, thinking about how much information that I have does the advocate really need to have, and how much of it is just to make my life easier. Being cautious about that and making sure that the client is fully informed about those kinds of communications are really valuable in making sure that information doesn't accidentally go too far. Documenting releases of client information are important, in particular if there are arguments later that the client has waived privacy rights. It may be essential for you to be able to demonstrate that you have not disclosed the client information to anybody or that you have very specific consent for any releases that have occurred and that those are limited. Helping a client find an attorney in certain circumstances may be really useful, although that's obviously more difficult in some parts of the state. And then lastly, the focus of this presentation, responding to discovery requests in order to help clients who don't have attorneys protect their information is an important way you can help them with their privacy rights. So I'm going to go through some questions related to possible bases for objecting to subpoenas, and we'll talk in more depth about these a little bit later. One of the reasons that you might want to object to a subpoena is that it's just inconvenient. You've got a lot of records at your program, and you don't really want to have to respond to this. So can you object on the basis? The answer probably obviously is no. If there are a huge amount of records that you're having to deal with, or it's going to take a lot of staff time, there are opportunities for you to ask for compensation for that, or for the photocopies, that sort of thing. But the mere fact that it's inconvenient is not a basis for objecting. Can you object to a subpoena because you really don't like the guy? The opposing party is your client's abuser, and you have no interest in helping him make his case. Not surprisingly, again, no. Discovery is not a voluntary process. It's compulsory. There are informal requests for information that you might get sometimes that it's perfectly fine to just say no to because that's what you feel like doing. But that's not the way the discovery process works. Some people don't want to object to subpoenas because their view is that the case that's in court really doesn't have anything to do with the records that you have. They're not relevant as far as you can tell. That may seem a little like a closer call, but the answer is no. You are not the person who gets to determine whether or not information is relevant. That is up to the court. The other thing is that the discovery process is intended to be a free flow of information. And that includes information that oftentimes is not directly relevant to a case. The provision of that information may still be compulsory. So the mere fact that you're not really sure what the connection is between the discovery request and what you have in your records is not a basis for objecting. What about if the subpoena wasn't properly served? Can you object on that basis? Well, the answer is maybe. Probably, yes, that is a basis for objecting. It's not a valid subpoena if it's not validly served. But the thing is that the consequence of them improperly serving a subpoena most of the time is going to be pretty inconsequential, because if they served it incorrectly, all that they have to do to fix that is serve a new one on you correctly. That isn't going to be that difficult for them. So it's not likely to be a way that you're going to make this problem go away. At most, it'll slow things down a little bit. But if you don't respond to a discovery request on time, if you mess up and forget about the subpoena, this might be a basis for justifying your failure to respond in a timely way to avoid waiving your right to object to the subpoena that later is properly served. Now, this is similar to one of the previous ones, but you may want to object to a subpoena because not only do you think the information that's being requested is irrelevant, but you're pretty convinced that it's so irrelevant that it couldn't even lead the other party to investigate further and find additional relevant information. And that is, in fact, a basis for objecting. So in the context of discovery, typically the standard for when information is discoverable is when it might lead or has the potential to lead to the discovery of relevant information, not if the information is itself relevant. So, for example, if you have records in which you have interviewed your client and made notes regarding a number of people that the client knew when she lived in another state. And those are people who were aware of some domestic violence or aware of some sort of information that maybe isn't directly related to this case, but they may be able to connect the opposing party with people who do have information about the present case. That would be a situation where those people's names, even though they don't have anything to do with the case that's currently being charged, they may actually have information that could lead to the discovery of relevant information. So objecting to that would not be appropriate. But there are some cases where things might be so extreme that there really is no way to imagine any connection. Example that I mentioned later on is if, for example, a subpoena requested information about your agency as opposed to about the client. There are some types of information about the agency that might be relevant. For example, they might want to know your working hours, which might be relevant to the question of whether you were available to be an alibi for the client during a particular point in time. So those, again, those sorts of things, even though it's an agency record, could potentially lead to the discovery of relevant information. On the other hand, a subpoena that asks what your salary is, hard to imagine how that could possibly connect to the case. So that might be a situation where you would be able to object on that basis. But the fact that you cannot see an immediate connection is not necessarily the end of the issue. If you object on this basis, it will most likely end up in a hearing, and they will most likely provide some sort of explanation for why they think it could lead to the relevant evidence. So I wouldn't count on being able to use this as a common basis for being able to resist subpoenas. It would be in very unusual circumstances. So the last one is, can you object to a subpoena because the information that it requests is privileged or confidential? And the answer to that is absolutely yes. And not only can you, you should, and under VAWA, you probably must. When you're making an objection based on privacy, really the important laws that you need to be able to cite are the ones that I mentioned a few slides back that relate to privilege and confidentiality for domestic violence advocates and sexual assault advocates and records of their programs. However, that isn't necessarily the only legal basis that you have for protecting your client's privacy in these situations. There are a lot of programs that provide services to the client that may be protected by other kinds of privileges or confidentiality protections under the law. And a really common example that comes up are counseling records. Many advocacy programs provide counseling to clients, and those counseling records, in addition to being protected by the advocacy privilege, are also protected by, most likely, by a mental health privilege of some sort. So when you're responding, it's important to think through what kinds of records you have for the client and not just focus on the advocacy privilege. The one caveat I have here, though, is that when you are objecting and you're raising these other potential issues, it's important to be careful in how you express the objection. The opposing party, or the not necessarily opposing party, I suppose if it's in a criminal case it would be just the defendant, but they may not really be aware of what kind of services you're providing. And so we're going to talk later about how to craft your letter that you're going to send that expresses your objection to the discovery request. But the important concept to keep in mind is to think categorically, not individually in terms of the individual client. So if your program is a program that oftentimes provides counseling to clients, it may be useful to, in your letter, say the records being requested may include counseling records because that is a service we provide to some clients. Counseling records are protected under this statute. So again, you need to be thinking about what kinds of records are in the file, but presenting that information in such a way that you're not giving the other side more information than they're entitled to. So I'm going to talk about discovery generally a bit and sort of what the process is about, what its purpose is, so that you have more context for why you're getting these requests and what kinds of things the court is considering when you come in to object. Generally speaking, discovery is about learning, finding information. In the context of the law, legal discovery is compulsory disclosures. Okay, so you don't, compulsory in the sense that it's not up to you whether or not you're going to disclose this information. The court, if information is discoverable, it is because either it falls into a category that is clearly discoverable or because the court has ordered you. It is a compulsory disclosure that happens at a party's request. It's not something that happens automatically in every case. It happens because the defendant or the other party in a family law case, for example, makes a request for that information, and they're doing it because it relates to pending litigation. There are a lot of different sources of information that affect what the rules are, and that's part of why this presentation is fairly complicated. That includes laws, the civil court rules, the criminal court rules, but it's even more complicated than that because, for example, the criminal court rules say that in many areas they have their own criminal rules, but then when the criminal rules don't specifically address an issue, you may be required to then look to the civil rules to say what and the civil rules may be in control, even though it's a criminal case. So don't expect that by the end of this you're going to be completely fluent in this and feel 100% comfortable knowing where to find every rule. The important point is to understand how and when to object and what your rights are during the process. So who? The issue here is that discovery requests are only made by parties to a case. And that's true in both civil cases or criminal cases. So, for example, in a criminal case, the victim is not entitled to file a discovery request because the victim is not a party to the case. The prosecutor or the state and the defendant are the two parties to the case. So they're the ones that are entitled to make discovery requests. Likewise, in a family law case, a witness to the case, let's say the abuser's mother, is not allowed to make a discovery request. Only the abuser, if he's the opposing party, is. The request for information made by a party to the case have to be signed by an officer of the court. So usually that means an attorney is going to sign it, although in theory, if somebody was unrepresented, they could take it to the court and have the court get a signature from the court. It's very unusual when you have an unrepresented party, and here I'm talking mostly about civil cases, like a family law domestic violence case, for example. You are less likely to see that kind of pro se party making discovery requests, even though they have the same right to discovery as they would if they had an attorney. They don't usually know they have that right, and it's more complicated for them to get subpoenas, so you're less likely to see that happen. But just keep in mind that they are entitled to make those requests as well. And the other who involved is who is receiving the discovery request. Usually, most requests for discovery are made by one party, and they're sent to the other party. So in a family law case, for example, the petitioner might file a discovery request that the respondent is supposed to fulfill by providing information. Occasionally, however, discovery requests are satisfied through third parties, and that's the situation that we're talking about today with your agency. Your agency is not a party to the case, but your agency is a third party that may have discoverable information. When is discovery available? There are some kinds of requests for information that can happen anytime, but discovery is only available while a court case is pending. that's why, for example, if there's a criminal investigation occurring, but no charges have been filed yet, there is no discovery available. You will never get a subpoena at that point. Likewise, after a case is resolved, there can't be any more discovery. So if a family law case, if it was resolved by entering an agreement and the final orders were entered, and then the other side decided, the opposing party decided that he wanted more information, he would not be entitled to file a discovery request at that point. The other issue with when is that there are notice requirements. So typically when records are requested, you're talking about 30 days to respond if you're going to provide the records. It's a little bit more fuzzy when we're talking about subpoenas to testify, but we'll talk more specifically about this later. So there are a lot of different types of discovery. So actually, before we get into these, maybe now would be a good time to see if there are any questions about some of this general information. If you do have a question, go ahead and type it in or raise your hand, I guess.
Just type it in.
Just type it in?
Mm-hmm. That might take a few,
Sure. We'll just pause for a second.
Any questions? It takes people a few minutes usually to.
Yes, I see one here.
Okay.
I hope everyone can hear me. I'm going to read this. It says, is there a difference between a subpoena for a civil case and a criminal case?
No, not really. The rules that dictate how and when you engage in discovery, those sorts of things vary a little bit in civil and criminal cases. But the actual document itself is going to look pretty much the same. It'll say State of Washington versus the defendant instead of your client versus the respondent in the title of it. But as far as the rest of the document is concerned, they should be pretty much identical. Okay. So again, feel free to ask questions at any point, but I'm going to keep going. So I wanted to just briefly mention the range of kinds of discovery requests that exist, even though you're not going to likely be dealing with some of these as part of your job. Obviously, probably one of the ones that people get most concerned about is a subpoena for deposition. Now, as I had mentioned a second ago, most discovery requests are against the other party, but there are some kinds of discovery requests that can be sent to third parties. Depositions are the latter. So a subpoena can be issued for any person who might be a witness to appear for a deposition. Another kind of, two other kinds of discovery requests are called interrogatories and requests for admission. These are essentially lists of questions that the other side is required to answer under penalty of perjury, fully, completely, and essentially they operate just like if you were being asked that question on the witness stand. It's held to maybe even a higher standard in terms of the completeness of the answer that you're obligated to give. The reason that you don't hear about these very much unless you work with people on family law cases is that interrogatories and requests for admission can only be sent to the opposing party in a case, not to a third party. So your agency won't receive these for your agency to answer, although your client might. A court may order a party to submit to a physical or mental examination. So I have on one occasion dealt with a criminal case where the defendant had filed a motion actually for the victim to do that, but it's typically not going to be something that your agency is going to have to address. Now the big one, a subpoena for the production of documents or physical things. That is one that applies to any person, not just a party. So this is one that, again, we know that agencies deal with fairly commonly. And then the last one is a subpoena to allow access to a location. So, for example, if a party wants to go to a house where, the scene of the crime or where an incident happened of alleged domestic violence, to inspect that location, that's something that a person could issue a subpoena to do. So you might be thinking, there are a lot of other ways that people try to get our information. Why aren't those on that list? And the reason is that these other types of requests for information are not considered discovery. They're important, but they're not discovery. So one example is informal requests for information. So anytime somebody gives you a call, asks you about your client, or whether it's somebody like me, an attorney who's also working with the client, whether it's the opposing party's attorney, those kinds of requests for information don't constitute discovery. Your client might be faced with requests to sign waivers. For example, law enforcement might ask the victim to sign a waiver. When they go get a SANE exam at the hospital, they'll probably be asked to sign a waiver. Those are not considered discovery. Again, these two things, informal requests for information, requests to sign waivers, and then the next one, public records requests, those are all things that happen even when there's no case pending. And that's an easy way to identify whether something is a discovery request or not. Is there a case pending? When there is a case pending, sometimes victims will receive a document called a notification of intent to request medical records, or sometimes these are also used for counseling records. That's a separate statute that has some additional privacy protections that require additional advance notice before subpoenas are issued. Those are not technically part of the discovery process. Court orders. You may be ordered to turn over information, and again, that's considered separate. And then the last thing, which we're going to talk about at the end of the presentation, which is subpoenas to testify at trial or to testify at a hearing. Those are still called subpoenas, but they're not for the purpose of discovery. They're for the purpose of conducting the trial. So, again, they're not considered part of the discovery process, but we will cover those at the end. And it is common for discovery requests to be combined. So specifically, if you were to receive a subpoena to testify at a trial or a subpoena for a deposition, those kinds of subpoenas may also include a subpoena that requires you to produce records. So it's not unusual to see them combined. And the reasons that your programs get these subpoenas, even though, as we know, the law protects the privacy of those records, there are a number of reasons. Some are more noble than others. On the plus side, we do have an ideal that the law is about seeking the truth and implementing justice based on that truth-seeking process. And the idea being that the open exchange of information is the best way to ensure that justice is done, which is why discovery is a broad process and, for example, may include evidence that isn't relevant directly, but just might lead down the road to finding relevant evidence. Again, the idea being to get all the information out there in the open and then let the court sort through it. Attorneys may feel like they need evidence to prepare for trial, even if they know that evidence can't be used at the trial as sort of background and context for themselves. So they may send you a subpoena, even if they know that it wouldn't be admissible. Some attorneys simply don't know the law, and so they're not aware that there is a reason for them to not request the information. And some of them just hope that you won't be informed enough to know that you can object and that you'll turn it over, and once they have the information, you can't unring the bell. It's already out there, and there's not a lot you can do to protect it. So that's why it's important that you be aware of the rights that you do have. Okay, so other than the who, what, when, why, and where, there are a few other big questions that tend to come up. Before I get into those, are there any questions right now?
So, and this is Netta. We'll just get, we'll just wait a minute because I know if you do have a question, it takes a minute to type it in.
Okay. So one of the other big questions, other than the who, what, when, why, and where, is really how official is a subpoena? How mandatory is it? They really look mandatory. The fact that an attorney is allowed to sign off on a document that says you are commanded by the state of Washington has always been entertaining to me because the truth is there are a lot of bad attorneys out there. And I don't just mean bad like malicious. I mean that there are a lot of attorneys who just don't know what they're doing. And part of that is that this is a complicated area of law. So they don't necessarily have to be incompetent. They may just not be experienced in dealing with victim rights. But it is not at all unusual that you would be dealing with an attorney who doesn't know all the rules. So that's part of why you need to think of a subpoena very differently from the way that you think of a court order. The fact that you've received a subpoena just means that there is some attorney out there who thought this would be a good idea. It doesn't mean it's legal. It doesn't mean it's enforceable. And it doesn't mean that it was done correctly. And it doesn't mean that it overcomes the legal protections that you have. So just despite the formal language on it, remember that subpoenas do not have the power of a court order. And specifically for SA and DV programs, a subpoena that's issued for your confidential records without a court order to back it up is under the law invalid. There is a specific legal process in Washington that we're going to go through that they need to go through before they issue a subpoena. So in fact, if you get a subpoena, you can probably assume that it is not valid. So if it's probably not valid, does that mean you can ignore it? And the answer is definitely not. Failing to comply with a subpoena and also failing to do what's necessary to object to it could result in you being found in contempt of court. That is, I don't want to scare you too much. It's not something that we hear of happening frequently, but it is just important to remember that just because you're pretty sure the attorney didn't do the job correctly does not mean that you can just ignore it. One of the big questions that I hear frequently is, do we need an attorney now that we got this subpoena? And the truth is that the initial response to a subpoena really doesn't require an attorney's assistance. There are two sort of scenarios that might happen when you get a subpoena, and here I'm talking about a subpoena for records particularly, but it would apply to a subpoena for testimony as well, usually. One of those options is that you go along with the subpoena. Maybe the client says, it's fine, I don't have anything in here I want to hide, and in fact, I actually want to use these records in court because I think they're going to help me with my family law case, maybe. So if you comply with the subpoena, absolutely no reason you need an attorney to do that. Likewise, it may be that you simply file an objection to the subpoena that is pretty generic. There are some specificity requirements that we'll talk about, but in general, an initial objection to a subpoena can be fairly vague, or at least, speaking in categories rather than about the individual client. And if you're just going to send a letter to the other attorney that says we're objecting to the subpoena, that's not really something you need an attorney for. If there is a court hearing, it's usually going to be helpful to have an attorney, but it's not always necessary. If you can't find an attorney, that does not mean that you can't go to court and still advocate for your program and your client. You can absolutely have a program supervisor appear pro se, just like any pro se litigant, and present their position. So the way that attorneys are supposed to go about getting client records are different for SA and DV programs than for other kinds of third-party records. In general, any attorney who's got a case going on can issue a subpoena to any potential witness asking for pretty much any potentially relevant information, pretty much any time during the case, and usually for any reason they want to. It's very, very broad. However, in the context of you guys' programs, there are specific laws that require a very specific court process that has to happen before they issue a subpoena. And the reason for that is that the laws that create privilege and confidentiality for these programs include a rule that any of the records that you have, the assumption is that unless there's evidence to the contrary, unless they can overcome the presumption, those records are not discoverable. The procedure that the other attorney is supposed to go through before they would issue any subpoena for your records is that they should first file a motion with the court in which they would describe specifically why it is that they want those records, what they think is in them that's relevant, why there's no other way for them to get the records other than through you, and why those records are crucial to the case. If they give good enough reasons, then the court is supposed to get copies of those records and review them in camera. In camera means in the judge's chambers. So the judge is doing this privately. It's not on the records are not filed. It's just the judge is taking a quick look at them. The court then evaluates whether there is anything important in the records that needs to be part of the case. And if there is any information that's relevant, is it more important to the case that that information be available, or is it more important to the victim that the privacy be maintained? And the court has to engage in a weighing analysis of those things. If the court determines, then the court enters an order. And that order has to say either, no, none of these are relevant, or if they are relevant, they're not relevant enough that it's worth harming this victim by violating their privacy. Or the judge might say, there are some parts of these records that are crucial and that are so crucial that any harm to the victim is outweighed. The court would then enter an order that specifies exactly what parts are necessary, and they would redact everything else and give just that limited relevant information to the attorney that had requested it. So at that point, the court might turn it over directly, or the defense might issue a subpoena at that point. We talked about these factors. One of the things to just keep in mind as far as arguing these issues is that it's important to remember both that privacy is important in an abstract sense, but there may also be specific trauma that could occur based on what the specific information is, and there might be other kinds of harm to the victim. For example, if the records include information about the client's immigration status or about criminal activity that they've engaged in. It's important to remember we're not just talking about abstract things, but there may be actual specific harm, and the court has to consider that in deciding how important is it really to let this information out.
And then, Emily, is that a situation, this is Meta, is that a situation where programs would need an attorney to help them argue those specific things at a court hearing, or does the in-camera review process happen without the program being present to talk to the court about those harms?
That's a difficult question to answer because, let's see, of notice. So we'll back up in a minute.
Okay.
But one of the things that's weird about this statute is that notice is required to be provided to the parties to the case, but remember, you're not a party to the case. So there's not really any specific provision saying that you have to be notified when this motion is filed. I think in practice, most of the time you are going to get notified. And if you're not, then hopefully the prosecutor, if it's a criminal case, or the victim who is required to get notice, hopefully they would be letting you know. So I'd be very concerned to hear, and please do type in the comment section if you know this to have happened in your county, that they've actually held one of these hearings without providing prior notice to the program. But you know, technically it's not required. That creates a weird situation where, in theory, if the judge finds that the initial arguments for why the record should be available is persuasive enough and the judge decides to do in-camera review, probably at that point your program is going to find out because the court is going to contact you and say, we need a copy of these records to review in camera. But most of the time, I'm hoping that people are getting this kind of advance notice, even though it's not necessarily specifically required under the statute. But assuming you do get notice and you're going to go in and argue against the motion, would it be helpful to have an attorney? Absolutely. Is it necessary? Probably not. Because the bottom line is those kinds of harms that might happen for your client, those are things that you know about, more than any attorney knows about. They're your records. And you are the one that has a really close relationship with the client. And so you actually are in some ways in a much better position to speak to the issue of what kind of detriment there would be to the client of releasing the records than an attorney would. The reason that an attorney would be particularly valuable at that stage is that there are ways of explaining that harm that are okay, and there are ways of explaining that harm that could potentially themselves violate the client's privacy. And so there's a very fine line you have to walk in terms of how specific you get. So an attorney may have a bit more ability to sort of evaluate the legal factors. But honestly, I don't see any reason why a person who's an experienced advocate, a supervisor, is not capable of going in and arguing, these are some of the reasons that my client would be harmed if this information was released.
And Emily, would you recommend when you say you that it be a program director rather than the advocate directly serving the survivor, like you mentioned on a previous slide?
Yeah. So if you are going to have somebody from your program go in to argue pro se, I do think that it's much better to have a supervisor for a couple of reasons. One is that they're better able to give general information about program policies and about, on a general level, the VAWA rule, all those sorts of issues, and may have more training in those kinds of issues than an individual advocate would. The other thing is that once you start testifying about factual information, there's a bit of a slippery slope that can lead to you inadvertently disclosing too much information and potentially creating a waiver. So if you're the advocate who's actually working with a client, and so you know from your individual meetings with this client, how they've expressed particular concern about an issue, and you start talking about that, there's only so far that you can go before you're actually talking about the information that is trying to be protected. So having a supervisor go in and argue the case, somebody who is not as familiar with the actual details of the specific client, may actually be valuable to have that kind of distance and to not be able to create the argument that, oh, well, this person is already functioning as a witness in the case, so they should be able to testify in the case because they're already acting as a witness, so why not let them continue acting as a witness? So I think it is better to have somebody else do it.
So, Emily, this is Mint again. If I can just try to summarize, I think, what we heard here, because I do think this is one of the common things that programs hear about is the request for their records. So if someone just sends them a subpoena, it's basically like, no, you're not going to have my records on the basis of a subpoena alone, but programs do still have a responsibility to respond to the subpoena by saying, I object, you're not going to get these records.
Yeah, and if a court hearing is scheduled, then you really do have a responsibility to go into court and to explain why specifically.
And explain why. And then if the court calls you and requests the records for in-camera review, they are required to provide them for the in-camera review.
Right.
And then hope that the judge makes a decision that's not going to be harmful to the survivor.
Exactly.
Right. Okay.
There are a couple of weird little differences between the DV and sexual assault provisions. I'm not sure that these actually make any difference. There are a lot of laws in this area where the actual specific wording of the law is not really the way people use the law. And I give the example that the doctor-patient privilege under Washington law, the way the law is written says that there is only doctor-patient privilege in a civil case. So in theory, in a criminal case, there is no such thing as doctor-patient privilege if you're just looking at the law itself. But that's obviously not the way the courts have interpreted it. Doctor-patient privilege comes up in criminal cases all the time. So I'm not sure that these distinctions would be an issue, but I just want to point them out. One is that the type of case, so in a domestic violence case, the provision providing the confidentiality says that they're considered confidential in any judicial proceeding, whereas the sexual assault is more specific to criminal sexual assault cases. The other distinction is that in the context of the type of records, in the DV statute it says client records, whereas in the sexual assault statute it just says records. So it may be that the sexual assault programs, their non-client specific program records would be covered more extensively than the DV programs. But again, this is not an area of law where there are any court decisions that clarify whether any of these distinctions matter.
Hi everyone, this is Kelly. I'll just add that the SA program records also includes what the statute called underserved populations providers. So that would be by and for agencies or community-specific agencies that are providing sexual assault services.
No, thank you. That's a good point. Okay, so keep in mind that most of the time, I would say, you should expect that this is going to be done incorrectly. Most attorneys, and in fact, the very few defense attorneys that I've had to deal with do it right until they've had to deal with me a couple of times, and I train them, get them in the line. But the best practice is to treat every subpoena as though it was lawfully issued and as though they were doing it correctly, and respond to it in the way that you would respond to a lawful subpoena, just to be on the safe side. Okay, so subpoenas for records. One of my father's favorite expressions is prior planning prevents poor performance, PPP. He says that a lot, although he uses a slightly more vulgar version of it. And the important point here is simply that the deadlines in these kinds of cases can be really short. And so it's great that you're attending this training. It's really important that you, as a program, think through your internal policies regarding who's going to be in charge of this as far as supervision is concerned. Having a form letter to use to object to subpoenas ready to go so that you can just send it off immediately. Making sure that your advocates are all trained. Making sure that your front desk staff is trained to be able to identify when something is a subpoena that needs to be put on in front of somebody immediately and addressed immediately, not just stuck in the inbox of somebody who's out on vacation. Policy as far as when you're going to get an attorney involved and who that would be, having those ready to go in advance is really important.
And this is Meta. I know that those programs that are receiving DSHS, domestic violence emergency shelter funding, are required to have those policies and procedures in place. And I know that Susan Hannibal has some sample ones that she sends out to programs that are looking to develop their own policies and procedures. Kelly, did you want to weigh into?
Yeah, I was just going to say that also accredited community sexual assault programs are also required to have such a policy, and WSCADV has examples that we can help you with there.
So be in touch with each other, in your networks, director to director or advocate to advocate, if you want to share ideas with each other on that, or so be in touch with WSCADV. They have sample ones.
So again, this is not legal advice, just telling you what sort of makes a lot of sense as one potential good process. The first thing that you really need to do when you get a subpoena is to read it. And I know that may sound silly, but I'm embarrassed to admit that despite being an attorney, I am one of those people who immediately clicks the accept button whenever iTunes pops up with a new contract or that sort of thing. And subpoenas are one thing that you really do want to read. One of the reasons is to make sure you know what it's requesting. It may be that it's requesting confidential client information, but don't assume that. It's possible you might get a subpoena that's for something completely legitimate. So figure out what is it actually asking for. Another thing to make sure you check for immediately is it just a subpoena, or is there also a court order stapled to the back of it? That might change what your obligations are. What are the deadlines? Those should be specified in the subpoena. And the subpoena also includes a full description of the process for objecting to a subpoena. So again, reading these can be really crucial and an often ignored step.
This is Meta. I know I've heard from programs that are having a tough time sometimes distinguishing between how do they know if there's a court order attached to it? And I heard you just say it would be stapled or clipped to the back of it.
One thing to look for is who signed it. if it was signed by a judge or was it signed by an attorney. Likewise, it'll simply have a different title. So in the caption at the top of the document, it'll either say order to do X, Y, or Z, in which case it's probably a court order, or it'll say subpoena for X, Y, or Z, in which case it's probably a subpoena. So the court orders, again, it's very unlikely that you should be getting any court orders with these subpoenas because, in theory, if they went through the process of asking the court, having the court do in-camera review, getting the court order, in theory, you should have found out because the court somehow got a copy of the records to do the in-camera review. So this is, again, but the reason that I mentioned, these possibilities, even though they seem a little out there, is that it is so common to do the process wrong, more common than doing it right. So I just want to alert you to the fact that you should check for that, even though most likely it's just going to be a subpoena. Obviously, as your program policy should state, there should be a supervisor that you inform immediately and provide a copy to. It's really important not to delay because of the short timelines with these. You need to consult with the client, figure out what they want you to do, and that's, again, why it's important for you to know what is the subpoena actually requesting, what information, because you can't make sure the client is making an informed decision unless you're informed about what the decision is.
And then this is Meta again. I know in the DV world, some of the laws and administrative codes that talk about your obligations to protect client confidentiality also speak to your obligations to, whenever possible, get in touch with the client when there's been a request for their records. So it's not just a good idea; it's also something you're supposed to do under the law. So.
Yeah, that's true. Yeah. And then so only after all of these things would you respond to the subpoena. So this is my when pigs fly slide, because in some sort of unusual circumstance, you might have a situation where a client agrees to go along with the subpoena and consents to you complying with the subpoena. And that's one of the reasons, again, that it's important to discuss it with them first. If they do want you to do that, make sure you get a written waiver from them, and that's very, as specific as possible. Check with your supervisor, make sure that you're following all of the VAWA policies and all the internal policies. And then the last thing is, if you are going to turn over information in compliance with a subpoena, you need to check the subpoena to determine whether it allows you to simply send the information, copies of the documents, or whether it requires you to show up at a certain time and place to provide the documents. Oftentimes that's the way these subpoenas are constructed, is it says you are commanded to show up at this place on this time and to turn over these records. But most of the time, if you just email, if you're going to turn something over, if you email the attorney who issued the subpoena, they will most likely be so delighted to hear that you're turning something over that they will be happy to waive the requirement that you show up in person.
Okay, hi, this is Meta again, and I know I have seen a couple of the policies and procedures from some of the programs, and some of yours say things like, even if the client agrees to comply with the subpoena and is willing for that information to be shared, the program may still try to object to it because there are sort of the larger issues around the program's position in the community and being viewed as a place where information is protected and confidential, and also trying to be in compliance with VAWA and other internal policies. So just take a real close look at all that and make sure you're having a very close and thorough conversation with the survivor about the pros and cons of voluntarily sharing that information in the court case. Sometimes there are reasons to do it, and most of the time it's not going to be a great idea. But.
And one of the factors there is really, again, going to be what is the subpoena asking for? Because if the subpoena is asking for sort of general program records that might be things your program has an interest in not releasing, that may be something you want to object to. But if the records are really specifically about that client, in most cases, these confidentiality laws are there, and are controlled by the client. They're the ones who have the right to say yes or no to the release. So, for example, if they wanted, if they said, go ahead and comply with the subpoena because I want to use these records in my family law case anyway, and you say, well, no, we don't really want to release these because they're program records, the victim would have a right to demand those records from you, get them herself, and then file them herself, right, in most cases. So, yeah, again, this is why it's really important to pay attention to what is the subpoena actually asking for. Okay, there's a question?
Yeah. Okay, and then so here's another question from a participant. If an organization is going to reject a subpoena on behalf of a client and they are not commanded to show up in court, should the organization send the objection letter to the court or to the attorney, or does that depend on who signed the subpoena?
We're going to get there in a second.
All right.
The short answer is that it goes to whoever sent you the subpoena. So usually that's going to be the attorney. But generally speaking, when you're going to object, just keep in mind that this process is pretty flexible. Most people, including the attorneys, don't really know what they're doing. And as long as you're acting in good faith and doing your best to follow your obligations, that is the best defense if you make a mistake. The odds of you getting into trouble, being found in contempt, and so forth are pretty minimal as long as you are doing your best to do what you're supposed to do. So just keep that in mind. So methods for objecting. This begins to get to the question that was just asked. So if you receive a subpoena for records, you must within 14 days serve on the person who is designated in the subpoena. So again, this is read the subpoena. The subpoena will say who you're supposed to turn the records or the objection over to. You need to send that person a written objection to the inspection or copying of any or all of the designated materials. So we're going to break down each of those things more specifically. So objecting in writing. The objection should be on your program's letterhead and should ideally be signed by somebody who is in a supervisory position in the agency. It is perfectly okay to have an informal conversation with the attorney who issued the subpoena about a number of different issues. That's the fact that your objection has to be in writing does not mean you're precluded from communicating with that attorney. So, for example, let's say you want to make sure you understand what the scope of the subpoena is, or you want to find out if you actually have to show up in person. You think you might be able to convince them to withdraw the subpoena. Again, perfectly fine to communicate with them by email, by phone, about those sorts of things. But once you get to the actual objection itself, that needs to be in writing. So the objection itself, the contents of the letter, is what this is about. So a couple things you need to do. The first is you need to make the claim of privilege expressly, meaning specifically. So you need to actually say the words, we object to the subpoena because this information is, the requested information is privileged, or something along those lines. The second part of that is that it shall be supported by a description of the nature of the records that's sufficient to enable the other person to contest the claim. Okay, so that doesn't mean that you have to say, we have counseling records from January 5th, March 18th, we have intake forms from this date, we have, it doesn't mean that you have to get involved with that level of specificity. What it means is you have to provide enough information about the records so that you can justify why they're covered by the laws creating that confidentiality. And to allow you to then cite the legal basis. So if you do have counseling records in there, or if your program oftentimes provides counseling, you may want to specify, our program oftentimes provides counseling to victims. Counseling records are not only privileged victim records for our program, but they're also protected by this other privilege. It's also a good idea in these letters to specify that the client has not waived their confidentiality rights and that you're not aware of any exception to these rights that would apply in this circumstance. That's really about all that has to be in this letter. The fact that there is a requirement of specificity does not actually mean that you have to be super detailed. It means you need to think about the categories of information that are being requested and why you're not obligated to provide those kinds of information. one of the ways that you can think about this is to balance the specificity of your objection with the specificity of the subpoena. So sometimes people will get subpoenas that simply say, produce all of your client records, or produce all of your records with regard to this particular client, or something extremely broad like that. In that context, my view is that you probably don't need to be as specific about what is in those records and why you're asserting the privilege. On the other hand, if the subpoena says we want the counseling records for January 15th, which was the week after the sexual assault was alleged to have occurred, and we're particularly interested in any references in those records to X, Y, and Z. In that case, it's okay to be a bit more specific, and, for example, to acknowledge, yes, this client's file contains counseling records, but those are protected. So, when you're getting really, really general subpoenas, I think that takes a little bit of pressure off of you to be as specific in your response. But in general, I would err on the side of not being specific, in the sense that once you let that detail out, there's no way to get it back. But if you're not specific enough in your initial objection, and the opposing party says, hey, this wasn't specific enough, you can always fix that later if the court agrees with them. If the court says, you need to be more specific about what we're talking about here so we can decide if it's privileged, then you can do that at that point. But again, just do your best, act in good faith, and you'll most likely be protected. It's important to remember that the deadlines are different depending on whether you're going to comply with the subpoena or object to it. Usually subpoenas say that you have about 30 days to respond, and we'll give you a specific date that you need to provide the records by. However, if you're going to object to the subpoena, you need to do that within 2 weeks of the day that you're served with the subpoena. Sometimes we miss deadlines. It happens. In theory, if you fail to do that, there could be consequences. The likelihood is that it's not contempt of court to fail to object to a subpoena, but if you don't object, it is maybe contempt of court to fail to comply with the subpoena. But again, keep in mind the statute uses words like may, it uses undefined terms like adequate cause, and the odds are, if there's a good reason that you messed up, if the person whose box the subpoena was put in was out on maternity leave, and so you didn't find it until later, something like that, the court, by and large, is going to be reasonable in terms of considering those things, because with these requests for records, there's usually not a really pressing deadline, in the sense that, family law cases, for example, or criminal cases may take several years to get finished from the time that they're filed. And so the odds that you're failing to respond by a particular deadline actually caused prejudice to the other party, is usually going to be pretty low. The more likely scenario is that if you don't file an objection, the court could essentially say you've waived your right to object at that point. And that becomes a big concern. So it's important to pay attention to the deadlines, but don't just give up if you discover that you've messed up. When you serve the objection, it's fine to just mail it, but keep in mind that you need to add 3 days if you're going to mail it. That's a court rule that you may be familiar with. So just be aware of that. And if you want to just be able to fax or email the objection, just get approval from the other attorney, like in an email, for example, to say, yes, we'll accept this stuff if you want to just email it to us. Although, of course, that does create additional privacy concerns related to the security of those electronic transmissions, so keep that in mind. If you end up having to release records, as far as the letter itself is concerned, there shouldn't be any problem with sending that by email, and most attorneys will accept that. Any questions at this point? And then I'm going to talk about what happens after you send your objection.
So once again, if you have additional questions, go ahead and type them into the question box. Okay,
Hi everyone, this is Kelly. I just wanted to revisit briefly what we were talking about earlier in regard to the records and information being the client's, and the client can, request them from you anyway and release them to the court themselves. So I just want programs to think about how if the records are going to be released anyway, it's really in your interest to be involved in that release, but you want to document it. So you want to get that signed release from your client if that's what they want, is to release the information, and then you have some control over that process.
Okay, so again, we talked before a little bit about the difference between a subpoena and a court order. The important thing to know is that if you get a subpoena and you file your objection on time, that stops everything, okay? You don't have an obligation to go to court to file some sort of motion to stop the subpoena or anything like that. This puts the ball back in the other party's court. They then, if they don't want to just give in to your objection, it's their responsibility to file a motion to compel. And again, like we were talking about earlier, if somehow you do get in the mail with your subpoena, or if you are served with your subpoena a court order, then in that case you definitely are going to want to talk to an attorney because something very strange is going on. So once they get the objection, and assuming they're not going to give up, then their next step is to file a motion to compel. At that point, you would go back and remember that process that we talked about earlier, where their motion to compel is supposed to explain why it is that they should be able to get this information, why it's relevant, why it wouldn't hurt the victim to release it, and so forth. The court can conduct in-camera review, and that whole process would happen at this stage. You could also at this stage consider filing a motion for a protective order. Protective orders are not always necessary because an order denying motion to compel is functionally more or less the same thing as an order granting protective order. The bases for a motion to quash subpoena, for a protective order, or just for an order denying the motion to compel, those bases are all pretty jumbled, and there's a lot of flexibility there. So really the court is probably going to be considering all the same factors. There are slight differences between civil and criminal as far as what the court has to consider as a basis for quashing a subpoena or entering a protective order. One of the key differences is that the primary bases for quashing a subpoena is that if it says you have to comply too quickly, that to be reasonable, if it requests privileged information, or if it's such a broad discovery request that it creates an undue burden, like if there are thousands and thousands of pages of records. In a civil case, the rules say that the court shall quash those kinds of subpoenas. In the criminal courts, the rule says they may. Whether or not they're dealt with all that differently, I'm not actually sure that there is that much difference in that kind of outcomes, but just keep that in mind. And then in terms of entering a protective order, they both have a good cause standard, both civil and criminal. The interesting thing about the civil standard is that it specifies that one kind of good cause is to protect a person from annoyance, embarrassment, or undue burden. So things like annoyance and embarrassment are pretty low levels as far as harm is concerned when compared against something as severe as the kinds of violations of privacy that may be involved. So that standard is actually pretty low, and I think it's fine to reference that kind of language even if you're talking about a criminal case where technically it doesn't apply because, again, these factors are also vague and so subject to interpretation by the court. That really what matters is how well you can explain why it would hurt your client, not the exact details of what the rule says. Limited protective orders are something that are important to be aware of. So protective orders could be absolute or they could be limited. A protective order might say the victim's information is privileged, nobody can access any of the information. Or it could be more limited and say things like only certain types of information are available. It might limit who can see it. For example, I've entered limited orders that say the court has ordered that we release some information, and so I've gotten an order that says we do have to turn over the information, but we only have to turn it over to the defense attorney, and the defendant is not allowed to have a copy of it, for example. Or there might be a provision making it explicit that they have to destroy the records as soon as the case is over. A provision that says that they can't share the information with anyone or use it for any purpose other than this case. Or you could put in a provision saying that if it's filed with the court, it has to be filed under seal. So again, think of protective orders as being ways of protecting a client's privacy, even if some of the information does have to be disclosed. And usually, in almost every case, you can get the other attorney to sign off on these by agreement because they're so glad that they're getting the information that they're willing to not look like a jerk, or they want to not look like a jerk by agreeing to those kinds of reasonable limitations. Just be aware that when you're dealing with these kinds of discovery issues and you're going to court, there are potentially attorney's fees costs available. So if you, for example, if they file a motion to compel, but it's ridiculous and they don't provide any good reason for it, and it's denied, you could ask for them to have to pay your attorney's fees. Or if you're required to turn over some records, you could be compensated for the expense of doing that. So don't be afraid to ask for compensation. Okay, so moving on to kind of separate subject, which is when you get a subpoena to testify at a deposition or a trial. We'll take just a quick stop in case there are questions.
This is sort of wrapping up the whole piece about subpoenas for records.
Yeah, that was it on records.
So again, if you have any lingering questions about subpoenas for records, please type those in.
Okay. Okay, so I'm going to talk about depositions first, and then after that, subpoenas for trial testimony. So if you get a subpoena to appear for a deposition, it's different depending on whether it's a civil or criminal case. If it's a civil case, all they have to do is have the attorney sign a subpoena and give you 5 days notice. Although usually attorneys will coordinate with you to try to schedule it at a time that you're available, and if they're really unreasonable about that, you can object. And in a criminal case, however, they are required to go to court and file a motion to get an order to have you deposed, and there's no specific requirement as far as the amount of advance notice. If they do go to court to ask for a deposition, they have to demonstrate that they can't just do that just because they want to. They have to, under Washington law, in criminal cases, they have to show that you are either going to be unavailable for trial, that you refuse to communicate with them, that's probably the one it's going to be, or for other good cause. In both civil and criminal, as far as how the deposition is conducted, for example, whether it's videotaped or there's a court reporter there, or a transcriptionist, the civil rules will apply even if it's a criminal case if there's no specific criminal rule on the issue. Again, as I mentioned, these can be combined with a subpoena for records and to ask you to bring the records to the deposition. Again, in these kinds of situations, you can file a motion for protective order or a motion to quash to try to get out of it. It is also one of the, in addition to privilege, one of the possible bases for objecting to this kind of subpoena is if it requires you to travel outside of your county. This rule is a little bit ambiguous, but it is something to look into with an attorney if you're subpoenaed in another county. But if you don't get a court order quashing the subpoena or an agreement from counsel that they're going to withdraw the subpoena because you're invoking privilege, you have to show up or risk being found in contempt. When you show up, you will have to answer questions, questions about who you are, who you work for, who you are, who you work for, and other basic questions that are not necessarily privileged. There are only two kinds of objections that can be raised during a deposition. It's very different from a trial. And again, this is because discovery is intended to be broad and to allow the free flow of information. So you can object to a question on the basis of the fact that you would have to violate privilege in order to answer it. You may have to give some information that's not privileged, like on what date did the privileged communication occur, who made the statement, were there any third parties in the room? Those sorts of questions that are not actually privileged information you will probably still have to answer. The other thing you can object to is the form of the question. So if the question is confusing, if they ask a question that's actually 3 different questions contained in the question, and so you don't really know how to answer it, if they're asking you to speculate or they're asking you to make a legal conclusion, for example, this person acted negligently. Those kinds of things you can object to because there's no good, you can't really answer the question unless the question is improved. You're not allowed to object based on things like relevance or hearsay or any of the other kinds of rules that you may have heard of in terms of what evidence would be admissible in court. Those are not valid bases for not answering questions in a deposition. If you refuse to answer a question in a deposition, whether it's for a good reason or not, the person who's deposing you can try to get a court order requiring you to answer the questions. And that may even mean that during the deposition, they get a judge on the phone and get an order from the judge over the phone. And if they have to go through this process, you might be ordered to pay costs if it turns out that you were wrong to object. So just be cautious and remember what the bases are that you're allowed to object on. It may very well be useful to have an attorney at least prepare you for a deposition so that you have a real clear sense of what you can and should not answer. After the deposition, unless you waive this right, and don't ever do this, after the deposition, you have the right to get a copy of the transcript and to make corrections. Now, that doesn't just mean, oh, there are typos in here. It also means that if you said something that was wrong, if they asked you for a list of 5, of all the different things that, fall into some category and you forgot some things, if you just got made a mistake, you are allowed to correct those at that point before you sign it. So just be aware of that and don't waive that right. Testimony at trial or hearing is a bit different from a deposition. For one thing, you can easily be required to travel to a different county. But if you're get a subpoena from a different state, that may be not valid. So that, again, would be a situation to check in with an attorney. There's no specific time requirement for how far in advance you have to get a trial subpoena, and sometimes that's kind of abused, and especially where we have these cases that get continuance after continuance after continuance. It may say one date, but in reality, the date that you testify is completely different. And this can be extremely frustrating, and unfortunately, I don't really have a good answer to how to fix that. But if it says you need to show up, yeah, you do need to show up. Subpoena for testimony at trial has to be served on you. That means personally served, abode service, which is where they take it to your home and leave it with a person who's, an adult at the place that can be reliably expected to give it to you. It doesn't mean they can just drop it off on your mailbox or tape it to your front door, but they can give it to, say, your spouse, for example, at your house. Or there is a provision to allow you to be served by mail, but that's only if you sign an agreement, so it would include a page that says, will you sign off on this waiver that says it's okay for me to serve you by mail? And you're not obligated to sign that. So that's not going to be common in cases where someone like you, they know it doesn't want to cooperate, is the one that's being subpoenaed. You're required to stay at court until after you're done testifying, unless the court orders you to stay longer. So it's really important with these subpoenas for testimony to be attentive to whether or not they're enforceable. And that's not what I said when we were talking about subpoenas for records. And again, the reason for that is the timing. With a subpoena for records, there's plenty of time if something goes wrong procedurally to fix it, because these cases can always be continued out for later. So if you get a subpoena for records and they don't serve it correctly, and so you object or you don't respond to it, they always have the opportunity to serve you a new subpoena for those same records and start over again. If they're in the middle of a trial, on the other hand, and you don't show up, there's not really an opportunity to fix that, most likely. So if you have a trial subpoena that's not properly served, you're in a much better position to simply not show up and not comply with that subpoena. The there is some case law in Washington that's seems relatively clear that a legally ineffective subpoena for trial means that you're not obligated to show up, and you can't be held in contempt for failing to show up if it wasn't properly served. Similarly, there are rules about what has to be in the subpoena in terms of a specific time and place, the information about what case it is, that sort of thing. And if it doesn't include that information, there is case law that supports the idea that you can't be punished for just simply failing to show up. Again, I'm not advising you to simply not show up. That's there are some risks involved in that strategy, but these factors are much more important, is my point, in the context of a subpoena for testimony than in a subpoena for records. So in the criminal rules, there's no real specific provision that addresses how you get a subpoena for trial quashed or you get a protective order. That doesn't mean that you can't try. So if you did get a subpoena for trial and you wanted to, and you had an attorney you knew who was, looking for an opportunity to get into court, and you wanted to have them appear to file a motion quash, I'd say go for it, give it a shot. But it's not clear to me from the rules that is actually the proper process for doing that. Really, the proper way of dealing with this, if you're going to be subpoenaed for trial, and this really shouldn't come as a surprise to the prosecutor, because they should be exchanging witness lists, or if it's a civil case, your client's attorney, if they have one, or the client if they're pro se. There should be witness list exchange. So you should have hopefully had a heads up that this was coming down the road. So in those circumstances, probably the best way of dealing with this is to have the prosecutor or the attorney, if it's a civil case that's on your client's side, to go to court and file a pretrial motion, it's called a motion in limine, to address it. Motions in limine are the kinds of motions that are addressed immediately before a trial that relate to how the trial is going to be conducted. And that's really the best opportunity to work with the prosecutor or work with your own attorney to have them work with the prosecutor, and to go in at that stage and ask the judge, right before the trial starts, before they start doing jury selection, to put some limits on these requests. So if you have this subpoena, for example, the prosecutor might go in and make an argument that you should be excluded as a witness because any information that's relevant that you might be able to testify about would be privileged, and that you have already asserted that you're going to raise that privilege and you're going to refuse to answer questions. That gives the judge the opportunity to consider this before the trial gets started and to address the issue, and gives the judge some flexibility. So it's possible that the judge would say, there's some reason, there's some evidence that's been presented that maybe there was a waiver with regard to some of your information. So the judge might enter an order that says, this person will be a witness, but they can only be asked questions about these certain issues. Or the judge might say, oh no, we're not going to have them presented as a witness at all because we know that everything that they could reasonably be asked, they're just going to assert privilege in response to. But it's really a lot better to get it dealt with at that stage. If you haven't, so if there's a subpoena for you to testify at trial and nobody does anything about it, and your day comes up and you show up to court, you go on the stand, and when the attorney starts asking you questions that relate to privileged information, you would, just like you see on TV when somebody is asserting their Fifth Amendment right to not incriminate themselves, you would say, I can't answer that question on the basis that, there's a legal privilege that does not permit me to answer that question. The problem with doing it that way, that may be your only way of doing it, but the danger of doing it that way is that if you've already been called as a witness, you've already been sworn in, maybe you've already explained who you are, who you work for, and now they start asking you the real questions. If the prosecutor then objects and says, no, we're objecting that on the basis of privilege, the judge may feel like, well, we've already put this witness in front of the jury. They're going to be really confused if this person gets up here and then doesn't actually answer any questions. So the judge might feel pressured to kind of let some of the information in to kind of split the baby. So again, really better if possible to deal with it before trial rather than on the spot. But worst case scenario, you should feel like you can assert privilege on the spot while you're testifying, and then the judge will rule on it. And if the judge says, I'm ruling that that's not privilege, you need to answer the question, then you're either going to need to do that or probably be found in contempt.
Okay, that was going to be my question. This is meant to, what's the responsibility then of that advocate who's been testified who's been subpoenaed to testify at trial? If the judge says answer the question, then the advocate has to decide to either answer the question or face potential contempt.
Yeah, and the consequences of contempt can be, the judge has a whole lot of discretion over what to do when they find somebody in contempt. That could range from jail to, financial penalties for your program, to financial penalties for you, to maybe excluding some of the judge might say, well, then if you're not going to testify for this side, I'm going to exclude one of the other side's witnesses. In the context of a request for records, for example, if you're held in contempt, the judge could enter an order that says for every day that you don't comply, your program is going to owe another, $100. Or could say that if if you don't provide those records, we're going to prevent the victim from, I'm going to exclude the victim as a witness, and so the case is going to fall apart because there's nobody to testify. The judge has a whole lot of range of remedies. So, again, if an attorney tells you to do something, that's one thing. If the judge tells you to do it, that's entirely different.
This is Kelly. Part of the reason it's so great that you're getting this information now is just that this is really important to think about ahead of time before your advocate or director is on the stand. What would you do in that situation, and what are you obligated to do based on your program's policies?
Okay, so let's say you're on the stand or you're at a deposition. One of the questions that may come up is, how broad is the privilege? And one of the things that I was noticing that I kind of make fun of attorneys sometimes and talk about how incompetent a lot of us are. But part of that is not really incompetence. It's just that there's so much information that for me, I feel fairly comfortable with these areas. But every time I read them, I learn something new. One of the things that I noticed this time was that there's a difference in the language of the privilege laws with DV and SA advocates as opposed to some other people. And so specifically, the law says that an advocate may not, without the client's consent, be examined as to any communication made between the victim and the sexual assault advocate or domestic violence advocate. In contrast, for example, with the mental health privilege, they cannot be examined as to any information acquired from the patient, but only those communications that happen when the patient was consulting with them in their professional role as a counselor, when the information was necessary to enable the counselor to render professional services. So what that potentially means is if you had your counseling session and then at the end of the counseling session you talked for a while about some other issues that aren't necessarily directly related to the therapy, maybe about getting services or finding an attorney or who knows what. In theory, the way the law is written, the counselor might have to testify about those other communications that were not directly related. It's actually maybe easier to think about in the context of doctors, which have the same issue, where the only communications that are specifically protected are those that were statements made in order to get treatment. So, for example, if you had a conversation with your doctor about insurance, that would not be covered. Whereas with the advocates, the law says that it applies to any communication, and that really, to me, seems a lot broader. Again, these things are always interpreted differently. The doctor-patient one supposedly only applies to civil cases, but we all know that's not true. So don't rely on this necessarily. But I just want to call it to your attention that as far as the way the law is written, you guys' privilege seems much more broad than anybody else's. Okay, so if you are subpoenaed for a deposition or trial, you may be entitled to some compensation, including the cost of getting to court. If it's in another county and you have to stay in a hotel, you might be able to get that paid for. You may be able to get compensation for the actual time you spend there that you're away from the office, or in some cases it may just be the $10 or whatever it is that they give jurors per day. So it does vary, but that may be available, so don't be afraid to ask for it. And as I've mentioned before, if you fail to comply with the subpoena, that can also involve financial penalties, as well as any litigation that may happen over whether or not there's a motion to compel, that sort of thing. Those can involve things like getting attorney's fees or getting compensation. So just keep in mind that even though the important part of all of this is the victim's privacy and those issues, that money does underlie this stuff. And I think this is a tool that we could take more advantage of. So for example, when you get one of these subpoenas that essentially says, well, we want all of your records, and then you go to court and they're put on the spot and asked, well, why do you think that these records should be available to you? What's your basis for overcoming privilege? And their answer is, I want the records. I mean, I think I'd like to see them. I think it would be really great. It would be useful for me. When they have that pathetic of an answer to the question why, there may potentially be, and therefore they lose because they have no good argument. You may be able to get attorney's fees or other kinds of financial consequences. And if we start asking for those, it may be that in the long run we'll be able to deter people from making really frivolous requests that are obviously inappropriate, because they'll know that if they are doing it frivolously, they risk having to pay for it. So that was pretty quick, but I did want to try to leave some time at the end for questions because I know that there was a lot of information. So go ahead and type in any questions that you have, and we'll wait a couple minutes to see what pops up.
Great, and this is Meta, and while the rest of you are typing, there's already one that's been waiting in the wings here. So, okay, the participant asks, this is not exactly a question for subpoenas, but it may lead to possibly being subpoenaed. We've noticed that we've been getting requests from clients, especially for our therapist, to write up a letter of support explaining their progress that the client is going through and how the abuse affected the client, etc. Our staff are hesitant to do such a thing for the client's court case because it may lead to being subpoenaed to testify by the opposing party. Can we use the privilege laws even after we write up a letter of support?
I think that's a really important question, and waiver is not an issue that I got into in depth in this, but it is definitely something to be keeping in mind, which is once a client has agreed to release certain information, the question then becomes, where does that stop? Do they get to set the limits for how much information is released or not? Now, and unfortunately, I don't have a black and white answer for you. So, for example, if there is a court hearing over whether or not records should be released and the court conducts in-camera review, the fact that the court conducted in-camera review does not mean that there's any waiver. If the court decides that some portion of those records are going to be discoverable and turns it over, that still doesn't constitute a waiver. So there are ways that information can be released that don't necessarily mean that the door is open to everything in those clients' records being available. And if you're ordered to turn them over your objections, then clearly that's not a waiver because you've objected. But when a client voluntarily goes along with releasing information, it can open the door to the release of other information. And the reason is this. There is a reasonable argument to be made that if information is private, it's private, and that you shouldn't be able to cherry pick the good parts of the information that are helpful to your client, and just release those, and then withhold all the information that might be helpful to the other side. And that's a similar situation comes up to when a person testifies. So you can't, you really usually can't, go on the stand and then testify about how you're a really honest person and you're known for being really honest and you always tell the truth, and then refuse to answer questions about how you got caught plagiarizing or cheating on tests in college, right? You've opened the door to that issue in by testifying about those things. Once you've made those kinds of assertions, the other side has the right to challenge you on them and say, is that really true? What about these counterexamples? So there are definitely situations where expressing some information about the case can open the door to those kinds of things. So if you have a client who is requesting that you provide that kind of information, you can do a few things. One is you can explain to them that they need to consider the potential consequences of that, and one of those potential consequences is that it might be that a judge would require you to then testify at trial or provide additional information based on the fact that you have voluntarily disclosed some information. It's not a guarantee that that'll happen, but that is a definite possibility. So just making sure that your client is informed about that so they can make an informed decision about whether this is really what they want is a really crucial step. Then if the client still insists that they want you to do that, another thing that you can do is be very careful about how you draft that document. So there may be certain things that you could disclose that wouldn't necessarily open the door to other information. For example, in a sexual assault case, one issue that comes up frequently is how quickly did the victim report it, because some people think that victims are more credible if they reported a sexual assault right away as opposed to if they reported it, a week or a month or a year later. So if the client wants you to provide information that says, this client sought our services on this date based on a disclosed sexual assault that occurred on this other date. That might be something that is actually useful to present in court, and that arguably wouldn't necessarily open the door to answering questions about any of the services that you provided after that initial intake. The other side could argue it and could claim that it opens the door, but you've got a pretty strong basis for saying, all of these counseling records are completely separate from the issue of on what date did she disclose to us. That's just one example, but again, thinking about how can you narrowly craft anything that you do provide to limit the degree to which the other side can say, well, if they get to tell that side of the story, we should get information about any conflicting information that might also be in those records.
Okay, a couple more questions. Another one is, do you request the compensation from the clerk's office or from the attorney who subpoenaed you?
I'd start by asking the attorneys, and if there's resistance to that, then I would ask of the judge at the hearing.
Okay, so bring it up at the hearing.
Yeah.
Yeah. Okay. A third question, in the objection letter, is there an RCW that we can or should quote?
Yeah, so one of the early slides in the presentation the one that contrasts privilege and confidentiality, I don't remember exactly what slide number that was, but that slide has the citations for both of the privilege statutes and both of the confidentiality statutes.
And everyone who was pre-registered for this webinar should have received a copy of the slides. Okay. This next question, will we be able to get the Q&A? I'm not sure. Could you type your question again? Because I'm not sure what you're asking there. I'm going to take a guess that maybe you're asking about the recording for the webinar, and yes, that will be made available. So if you want to listen to this all over again, you can. Or are you asking, do you want me to share the questions in writing? I can do that too. So are there any other questions? Okay, thank you for clarifying. So yes, she's asking if I can share the questions that people typed in back to the group, so I'll try and do that. Okay. I'm not seeing any other questions come in.
Okay. Well, my contact information is on the first page of the first slide, so feel free to contact me if you have questions. I know this was a whole lot of information, and a lot of it is fairly confusing, including confusing to attorneys. So definitely open to answering questions later, and I just appreciate all of you bearing with me, not the least of which I want to thank the interpreter. I know that doing this whole thing yourself, given my rate of speed in speaking, is not the easiest thing, so thanks so much for that. Yeah, I guess definitely feel free to contact me if either if you have general questions after the presentation, but also, we do provide technical assistance to attorneys, advocates, and other people who are working with sexual assault victims around the state. So if you're a sexual assault program and you get a subpoena and you have questions, I may not necessarily be able to give you legal advice or represent you, but I may be able to help walk you through some of the basics to make sure that you're doing it right. For example, if it's the first time you've gotten a subpoena and you just aren't feeling confident, sometimes just talking to somebody and running through it can be really helpful. So feel free to give me a call or send me an email if anything like that comes up. And thank you.
Well, this is Meta. Emily, I just thank you so much. I'm really impressed with the way you put the information together. I found it really helpful, just kind of understanding the process, the context. I really appreciated hearing, why attorneys are asking us for this information and how it contributes to the overall justice process, and then the specificity about, what are the steps that we can take. So thank you so much for coming and presenting to us. I just really appreciate it. Did you want to say?
Hi, everyone. This is Kelly. We also just so appreciate Emily, all the practical information for advocates, and appreciate WSCADV asking us to be a part of this.
Yeah, it's great. So thanks to all of you, and be in touch. If you have other questions, go forth, do great advocacy. We will talk to you all later.